calling together SJC-11630, Commonwealth v. Michael Cowels, and SJC-11631, Commonwealth v. Michael Mims.
Mr. Apples, please proceed.
Good morning, Your Honors. David Apfel on behalf of Appellant Michael Cowels. With me is Phil Cormier, who's representing co-appellant defendant Michael Mims. We are splitting the argument. I'm going to focus entirely on the newly discovered evidence, and Mr. Cormier is going to focus on all of our arguments with respect to ineffective assistance of counsel. Notwithstanding the fact that we believe that all of the arguments may be viewed separately, but ultimately we would hope and expect and ask Your Honors to view the evidence in its totality, because we believe that it's the totality of the evidence, the newly discovered evidence, combined with the evidence that could have and should have come in through effective counsel, that should result in a new trial for Mr. Cowels and Mr. Mims.
Let's focus on the bloody towels for a moment. Is that a subject that you're going to touch upon?
That was the focus. That was going to be the focus of my argument as well. And the bloody towels are in the record at Appendix 534.
I take it the expert essentially testified that, I mean, not the expert you now are promoting, the expert at trial testified that essentially this couldn't have been the defendant's blood?
No. I think that's what the Commonwealth says. I mean, the expert at trial was a serologist for the Commonwealth, Mary Lumley.
Right.
And she testified that something called an ABO test was done on the towels. An ABO test has a range of possibilities.
Right.
If you get a 4+, it means it's absolutely positive for whatever it is, A or B or O blood. If you get a 1, it's suggestive. If you get something below 1, you can't really conclude anything. In this case, Ms. Lumley's testimony was that when they tested the towels with the ABO test, there was a slight positive reaction, not even enough for a 1 rating. And she testified repeatedly, and it's in the transcript, volume 7, I believe, between pages 72 and 84, testified repeatedly that the results were inconclusive. And it could have been anybody's blood. And that enabled the Commonwealth to argue, and argue with force at trial, that the towels were corroborative of their key witness, the central witness in their case, namely Robert Sally, and I would suggest was the key evidence corroborating Sally, who came to the court, who came to the trial with lots of baggage, lots of bias.
Counsel, may I
readily
ask,
impeachable.
How I did not read the transcript in the case in its entirety, but can you explain to me what the Commonwealth's theory of relevance was for the towels if it couldn't be connected to either one of the defendants? I mean, how does this towel even come in?
Oh, because they were able to argue that it was the blood of the defendants and the blood of the victim.
But based on what? I mean, the test didn't.
Sally's testimony, Your Honor, Robert Sally's testimony was that, and it's the key part of the case.
No, I understand that. He testified that they came and they washed up, and when they left, these towels were there.
And he testifies that the towels were clean when they went into the bathroom. He doesn't touch anything in there. He doesn't touch those towels for several weeks. The Commonwealth then executes a search warrant several weeks later, and they find these towels in the bottom of the hamper in the bathroom covered with blood. And these are, you can see, it's covered with blood. This is not a shaving incident. This is a lot of blood. And so they're able to say what corroborates Sally is blood evidence. It's stuff you can see. And they point to the sneakers, which Mr. Cormier is going to talk about, but the blood evidence on the sneakers was occult blood. It was invisible. But here, this is a picture's worth 1,000 words. And they didn't have just a picture. They had the bloody towels themselves. And could say,
it's relevant.
this supports what Sally, who's otherwise non-believable, is telling you.
So it's relevant because he says they were clean and now look at them.
Oh, and now look at them.
And it's not made irrelevant because the testing says, well, it could be anybody, so ergo it could be these two defendants.
That's right. In fact, I mean, the conclusion at trial, the suggestion at trial was that it had to be, it could only be these two defendants. You know, I would suggest that the new DNA evidence, I mean, the test under Grace is, would it be a real factor in the jury's deliberations? I would suggest to Your Honors that the new DNA evidence, specifically with regard to the towels, is transformative of the case. It is, it's not merely, the DNA evidence the new DNA evidence goes to two things. The vaginal swab, which I would suggest is merely corroborative of testimony given by Michael Cowels, not testimony, statements made by Michael Cowels. And in and of itself, the new DNA evidence with regard to the vaginal swab probably would not result in a new trial. But the towel evidence, that goes to a fundamental issue. And I would suggest is exculpatory in two ways. I mean, the court, in the court's case, and there's a court case, this court's case from 1983, Commonwealth versus Liebman, where the court said, evidence which impeaches the credibility of a key prosecution witness is exculpatory for the defendant. So in the sense that, and Liebman is 338, 483 at 489, the sense in which it's exculpatory here, it impeaches Cowles' testimony, which, I mean, it impeaches Sally's testimony, which we've already talked about. The Commonwealth, with the new DNA evidence, wouldn't even be able to get the towels into evidence at all. But with the new DNA evidence, this would become evidence that the defense would introduce. If I'm representing the defendant in this case, armed with the DNA evidence, I would be waving around the towels. It would transform the case in that way. I would be suggesting to the jury or arguing to the jury, not only is Sally a liar and does this evidence impeach him, but maybe he's telling the truth about somebody coming to the house at 11:30.
One more question before your time is up.
Okay.
The Commonwealth says that you could have done this, or not you, but whoever was representing the defendant at the time of the trial, that it's not newly discovered evidence. What's your position on that?
Well, I mean, there are two arguments to that. One is the Commonwealth has waived the argument because it was never raised in the court below. In fact, in Justice Connolly's opinion, he notes in a footnote that he's assuming it's newly discovered because the Commonwealth doesn't challenge the newness of it. They're making the argument about it not being new for the first time here on appeal. And on this record is unanimous with respect to it being newly discovered. You could look at the affidavit of Matthew DuPont from Cellmark, who says that the test used here, the STR test, was not available in 1993 when the killing occurred, 1994 when the trial occurred. You could look at the article that the Commonwealth now cites for the first time on appeal, the Thompson article, which says that the STR was in an experimental phase in 1993 and 1994. You can look at the evidence about the amplification kit that's used here, which no one disputes was not available until years after 1994. And even the DNA tests themselves as a legal matter, it wasn't decided by this court until 1997 that this particular test was even admissible. So I think that as a waiver matter, the Commonwealth loses on that, and on the merits, they lose as well. This is truly newly discovered evidence.
Thank you.
Thank you, counsel.
Thank you, Your Honor.
Good morning, may it please the court. Philip Cormier from Michael Mims. I'm going to focus on the ineffective assistance claim here. That involves a course of conduct involving a series of failures on the part of trial counsel, including the failure to investigate and defend effectively against the bloody sneaker evidence, the failure to call Patricia Zampatella and Randy Jones as witnesses, and the failure to marshal the evidence and argue to the jury in closing that Peter Rowe, Ms. Muskosia's boyfriend, had the opportunity and motive to have murdered her that night.
I just want to clarify, you represent Mr. Mims,
I
correct?
do.
And so obviously you're arguing on behalf of Mr. Mims, but Mr. Cowels has the same ineffective assistance.
That's
Different
correct.
lawyer, but same argument.
Same argument. It only differs with respect to Mr. Cowles is relying on the failure to call Mr. Jones, and we are not. Otherwise, same argument.
Okay.
The bloody sneaker evidence in this case played a critical role, excuse me, as direct evidence of the defendant's involvement in the murder and confirmation of Mr. Sally's testimony in a similar manner to the bloody towel. The Commonwealth hammered that home in its closing argument. The defense response to that was a very tepid and ineffectual cross-examination of the Commonwealth's blood expert, Robert Sullivan, with respect to his testing on the sneakers.
Can I ask you a question? I wasn't clear from the record. So I get the testimony and the affidavits that say that this was at the time a presumptive test and they should have done a confirmatory test. Was that the protocol then, that you have a presumptive test but it has to be confirmatory?
According to our expert, Peter DeForest, you do have to do a confirmatory.
Now, I get it now.
But back then as well, I think.
That's what he says is back then?
I don't know if he uses the words back then, but I think that he understood from the get-go that this particular test, the orthotolidine test, is meaningless without a confirmation. What the test is used for is to, if you get a negative,
No, I understand that part of
Don't
the
have to
argument.
go
I just
further.
wasn't sure what was available then.
So is the LMG testing, the testing that Cellmark did now, are you saying that that testing was available at the
Yes.
time of trial?
Yes.
The LMG testing?
yes,
not-
Matthew DuPont.
And that would be the confirmatory testing?
No, it's another presumptive test.
Another presumptive
It's
test?
the only presumptive test that Cellmark uses. It's been validated by Cellmark. Mr. DuPont's affidavit indicates that they use that to determine whether they should do further testing. They did that test on the sneakers in this case and found that there was no blood on the sneakers.
And they said that if there's a negative, it's a negative, but you can
Correct.
have a false positive.
Correct. It's conclusive if it's negative.
So you wouldn't need a confirmatory test if the
Correct.
presumptive test showed a negative?
That's correct. It's only if you get a positive result using this test that you have to go on and do a confirmatory, a more specific test for blood.
And what, did that more specific confirmatory test exist in, at the time of trial?
According to Dr. DeForest, there was confirmatory tests that were available depending on whether or not the sample size was of a sufficiently adequate size.
And the answer for here would be?
I believe that in this case, given that this was occult blood, that the sample size was not large enough to do any confirmatory testing.
Was there any evidence that the blood, that there might in fact have been blood on the sneaker, but given the passage of time, there would have been a deterioration to the point that it would no longer be testable?
The only evidence of that is an affidavit that the Commonwealth submitted from Gwen Pino, who makes a statement that it could have degraded. There's no other evidence beyond that. When we made our request to test this item, there was a stipulation filed in the Superior Court. At that time, the Commonwealth voiced no objection that Mr. Sullivan's testing had exhausted the sample or that the sample had somehow degraded over time. I suspect that they were secretly hoping that when we did the test, it would come back positive, but it didn't. And it's only now that they've raised this issue through Ms. Pino's affidavit that, possibly Mr. Sullivan consumed it or possibly it degraded. However,
Could you just remind me what Mr. Sullivan's test showed?
Mr. Sullivan's test showed that in the crevice of the sneaker, of the left sole, of the left sneaker, excuse me, that it tested positive.
And that was the orthotolidine test?
And that's the orthotolidine test.
And no confirmatory test?
No confirmatory test was done. He testified that that indicated the presence of blood. Dr. DeForest, on the other hand, says that that test is meaningless without a confirmatory test, and that you can't say to any reasonable degree of scientific certainty that you have actually found blood on the sneaker. The problem here is that the defense did little to no investigation whatsoever, no investigation into the sneaker. No defense expert ever examined it. Nobody ever tested it. They presented no testimony from an expert such as Dr. DeForest, who could have testified that you have to do this confirmatory test, otherwise you have a meaningless result. And without that, unfortunately, Mr. Cowles' counsel in closing argument conceded on at least 3 occasions that there was blood on the sneaker. Had he had the assistance of an expert, had he done the diligent investigation, he never would have made that highly damaging concession at all. In fact, it would have turned it on its head. He would have attacked Mr. Sullivan's findings and argued that to the jury.
Your argument is obviously double-barreled. One, mistake not to challenge just orthotolidine by itself.
Correct.
2, not to retest or seek to retest and discover, as you say was discovered now, that there in fact is no blood.
That's correct. And then to take that one step further, in the context of the entire case, we have Mr. Saley, saying that this sneaker, that he's shown this bloody sneaker.
Can I turn you to Ms. Zampatelli?
Yes.
So I take it you would agree that the only thing that she could have testified to is not the contents of that conversation, but just the fact that he called and it sounded like it was in a bar?
That he had called and it sounded like he was calling her from a bar. She could have elaborated on that by describing what exactly she had been hearing, whether, glasses clinking,
the ambient
plates.
noise, right. But she couldn't have testified to any conversation that they'd had.
In terms of the hearsay objection,
Yeah.
I think that it would probably have been excluded on a hearsay ground, yes.
But you were saying, your point is, even that much would have confirmed the statements that they were in
That's
fact
correct.
doing what.
That's correct.
Now, was there impeachment of Barbara Cowels' testimony that Cowels and Mims and the victim were at her house at 11 p.m.?
No. In other words, there was no.
So basically, no one challenged Barbara Cowels' credibility.
No one challenged the fact that she had seen them with Ms. Moscotia. It was actually 11:20 p.m.
So there's no doubt that they were together at that time in the evening.
That's correct.
All this focuses on is the period of 10 p.m.
Yes, it's an earlier time period. Thank
All right,
you.
thank you. Your time is up. You may begin.
Good morning, and may it please the court. Hella Saxa on behalf of the Commonwealth. With me is Janice Smith, who was the motion prosecutor in this case. This court should affirm the denial of the defendant's motions for new trial. Judge Conley here was correct that the defendants did not raise a substantial issue and that no evidence was presented at the motion that would have cast any real doubt on the justice of the conviction. And turning to the towels. First of all, I would have to correct my brother that the towels were bloody in their entirety, as the picture in the record appendix appears to suggest. The testimony throughout was that the towels were soiled and they were dirty, but that a blood stain was found at the bottom or near the hem of the towel, and that it was cut out, and the area surrounding that stain was indeed free of blood.
Are you saying Mr. Sally testified they were dirty?
Yes, and the...
Didn't say they were clean. He said they were dirty.
They were dirty, yes.
What did he say they were?
He said they were clean when he had placed them in his bathroom, and afterwards they were dirty and they were soiled. And they were throughout the testimony by the criminalist and the attorneys throughout described as soiled and dirty towels, not as bloody throughout. And there is a...
But I take it the inference would be that the dirt and/or blood came from the defendants. Is that correct?
There is nothing about the
Well, if they
dirt.
were clean when he put them in there and they weren't used thereafter, isn't that?
Correct. However, the blood was... The blood evidence at trial was confined to a very small stain that was removed in a cutting, and that was then reanalyzed by Cellmark, and there's some discrepancy in the affidavit.
Well, how was it argued?
I'm sorry?
How was it argued?
How was?
The bloody towel.
The bloody towel, the counsel, defense counsel, both used it in a very creative...
No, not defense counsel. How was it argued by the prosecutor? Not at all?
It was described as a bloody towel.
Right,
Yes.
okay. So you
However,
can't minimize it too much, or they're really going overboard and making an argument based on no evidence. But so you...
No, they are not. There was blood discovered on it. However, that blood had a weak reaction to type A blood, and that was...
Not what they argued. That's not what prosecutor argued that, though.
That is not what the prosecutor argued. However, that was a very thoroughly argued piece of both defense counsel's closing argument, that they established on cross-examination that there was a weak reaction to type A blood as a result of the towel, the stain testing on the towel, and that none of the defendants nor the victim had type A blood. They all had type 0 blood, and that therefore the blood on the towel could not have come from either defendant nor the victim. And that was, that point was brought home thoroughly during closing arguments, and it provided counsel...
What did the prosecutor argue during closing argument about whether the blood on the towel could have been the defendant's blood?
He never specifically said that it was the defendant's blood or the victim's blood. He said there was blood on the towel. He made no reference to the type A versus type 0 testing. He said there was blood on the towel and that it therefore confirmed Robert Saley's account. However...
Robert Saley's account was that the defendants had used the towel, right?
Well, he said they went into his bathroom to clean up. They came out...
Afterwards, the clean towel was dirty.
The clean towel was dirty.
So
it was found...
the only inference is that it was the defendants who used those towels.
That was the inference that the prosecutor alluded to, correct.
Even though there was no evidence of it being the defendant's blood?
None of what he said was wrong. He said there was blood on it. Saley described the towel was clean. Now it has a blood stain. Therefore, jury. However, defense counsel both used it as essentially the only piece of evidence they had to actually discredit Saley's account. They could say there was type A blood, a weak reaction to type A blood on the towel. Therefore, it could not be related to the defendants or the victim.
Are you saying that the Commonwealth did not, during this trial, heap relevance onto these towels as evidence of the defendants having committed the murder?
The towels figured into the calculus. However, they play nowhere near as big a role as defense counsel now paint the picture. They were one piece of evidence, and they went both ways. They supported the Commonwealth argument, and they likewise allowed the defense to say Robert Saley's story is not correct because the blood that the Commonwealth makes us all believe is the defendants or the victims cannot be their blood.
Well,
therefore,
they're doing that because the Commonwealth has elevated the importance of the towels. Otherwise, they don't need to bother with it, right?
The Commonwealth had so much additional evidence that this fell within, it was one piece of evidence among many.
Pretty powerful evidence, though, wouldn't you say?
I'm sorry?
Pretty powerful evidence, though, wouldn't you say?
I think Judge Conley was the only person, aside from the defendants, who was at the trial and at the motion for new trial. And he did not think that this was the key piece of powerful evidence. And he's the only one who was actually there. None of us attorneys were present at the motion.
What corroboration, apart from the towel, was there for Sally's testimony?
There were the sneakers, which the defendant Cowels held up to Sally's face. He threatened him, pointing to what Sally and the defendant perceived to be blood, visible blood on the sneaker, said, if you, this happens...
But that came from Sally.
That came from Sally, however, it was corroborated.
Tell me what evidence that did not come from Sally corroborated Sally's version that they came to the house and they cleaned up the blood in the bathroom.
This point was, the sneaker was corroborated by Richard Polovic, who confronted the defendant with the notorious sneakers. A few days later, the defendant then, in response, threw the sneakers out, and they were found later in the bushes. There were the sneakers that Michael Mims was wearing the next morning that had been given to him on the after he had cleaned up himself. They were recognized by Chris Winham as being Sally's sneakers. And he questioned Mims why he had thrown out his perfectly good, expensive pair of Reebok sneakers. He said they were squeaky after the rain. There had been no rain. Sally described that the defendants referred to the victim as a dirty pig. They told him that they had killed her because, that Sally would read in the paper how they had killed her, that Cowell said he would go to jail.
Now, this is who said this?
I'm sorry?
Did you say that Sally is saying this?
Sally is saying this. However, the defendant used the same words in their statements to the police. They described the victim as a dirty pig. Cowles, when he learned that the victim was indeed deceased and not just missing, again used the same words, says, I don't want to go to jail. He had made a reference to that to Sally before. The defendant, Cowles, told the police that there had been sexual relations between him, Mims, and the victim on the night. That was, again, something that confirmed Sally's account to that effect, that the three had gone into his bedroom and engaged in sex. Again, that is also now confirmed by the vaginal swab that...
Not for Cowles, it isn't.
Cowles told the police that the victim had given both of them a hand job on the night. I submit that that qualifies as sexual relations.
Would you agree that the prosecutor was asking the jury to draw an impermissible inference from the blood that was on the towel, but that the jury were smart enough to see through it?
No, it was not.
So what was the permissible inference that could have flowed from the fact that the blood on the towel was type A and nobody else involved in this case had type A blood? How is it even relevant to the case?
Well, it is relevant because in the prosecutor's account, it confirms what Sally had testified. There was...
How?
The testimony about the type A blood is more or less cuts both ways. The analyst testified the result is inconclusive, so it could be anybody. But at the same time, she recorded a result of type A blood that, however, was not strong enough to fall into her criteria of allowing her to record it as a positive result. So both sides could use the evidence and marshal it their way. With regard to the bloody sneaker here, there are two types of blood on this sneaker. One is the occult blood in the crease up on the sole, not even in a part that would have touched the ground. That is now under discussion. The other blood on the sneaker is that was visible, perceived blood that was never accounted for in a scientific test. But Sally testified that the defendant held the sneakers up to his face, said, this is what happens if you F with us. And the defendant then throughout the notorious sneakers when he was confronted by Polovic a few days afterwards, again confirming that he believed that there was actual blood on these sneakers. That blood could have washed off, as Sullivan testified, because the sneakers were exposed for almost a month lying outside. And here again, in terms of this being ineffective assistance of counsel, counsel in closing arguments told the jury in a very creative way how the blood that was up in the crease under the sole of the shoe, was never determined to actually be human blood. It was blood. On cross-examination, it was tested whether maybe it could have been plant protein. But even if it was blood, it was never established that it was human blood. And he argued to the jury that where the scene of this crime was, for lack of a better word, a bloody mess. The victim was lying on a platform. She was covered in blood. Photographs of her her hair is red because it is stained in blood. Her clothing is soaked. Yet there is one tiny speck of blood on the upper inside of the defendant's sole. And counsel argued to the jury that really makes absolutely no sense, that these shoes would not be as soiled as the victim if they had been, if this blood had any relevance at all.
Were there confirmatory tests available at that time, and what was the protocol?
According to Gran Pino, who from the state police, there was no confirmatory test available at the time that would have been conducted by the state police. And Judge Connolly, I'm sorry?
It was unavailable, and that's why it wouldn't have been done, or they wouldn't do it even? I'm sorry.
That test was, I don't want to quote her the wrong way, but that was not a test that would have been done at the time.
Wasn't the state police protocol to do a confirmatory test?
No, not under those circumstances.
May I ask you, go back to the newly discovered evidence issue. You argued in your brief that it wasn't newly discovered because I don't really understand your argument. So could you explain to me why you say this DNA test that the defendants have now done on the bloody towel is not newly discovered?
Well, the Commonwealth is certainly not challenging that in 2014 DNA evidence would be admissible. That is not our point. However, here, this testing was being conducted at the time this trial took place. In fact, I believe...
So the test that was done in 2007, I believe it was, could have been done in 1993 when this case was tried?
That form of testing was... certain forms of testing were available at that time.
No, this one.
Well, this particular commercial kit that was used in conjunction with the PCR testing certainly was not available, but kits of that type were. However, the main point here is that there was... The Commonwealth today would still challenge the inconsistencies in Selmark's affidavit, and that at best here, the defendants could prevail by receiving an evidentiary hearing at which the Commonwealth then would challenge those inconsistencies in Selmark's affidavit, and not just because something might be new evidence does not automatically allow the defendants a new trial.
But this wasn't raised before Judge Connolly.
The Commonwealth did not challenge that point.
A little late now, isn't it?
Well, it would still be, if this were to go back, and it by no means should, to an evidentiary hearing, the Commonwealth would not be precluded from raising these issues in regards to Selmark's affidavit.
What issue do you say you would raise? That the Selmark test is wrong, or that it was available in 1993?
No, there's merely there's an inconsistency in Selmark's testing and the affidavit with regard to the towel, where it is not entirely clear whether they tested They did the DNA testing on the entire towel as opposed to merely the cut portion, and that is pages 63, 66, and 68 of Cowels' record appendix, where the table that Cellmark provides does not match up with the narrative of the affidavit as to what was tested and what the results of that were.
This was not raised before, I gather.
That wasn't, but that issue never, because there was no evidentiary hearing, it never could have been raised to that effect.
All right, thank you.
Thank you very much.